Well, good afternoon. We're now rapidly notching up the participants entering the Zoom seminar, so we're going to start. Can I say how wonderful it is to see all your little faces peering out of the screen at me? It's like an episode of The Muppet Show times 10. This is, of course, not the King's Chambers cost team analysis of the World Cup. Today, Craig and I are going to talk about Belsner and Karatysz, and perhaps more significantly, what the ramifications and significance of those cases and the principles they discuss will be going forward, and also to look at points that solicitors might want to think about when structuring retainers, when giving clients cost estimates, and when considering their billing practices as we go into a post-Belsner world. Before we get going on all of that, though, I'm conscious that there will be some people listening to this who aren't up to speed as to what happened in the Court of Appeal in the Belsner case and the related case of Karatysz. So let me just start then with a potted précis of what they're about and how we got here. The origins of Belsner and Karatysz probably stretch back to 2012, 2013. When the LASPO Act came in, effectively abolishing, for the most part, the recoverability of success fees, and also, of course, ATE insurance, but let's stick with success fee for now, on an inter partes basis. This didn't, of course, abolish solicitors charging success fees. It did, of course, mean that success fees were levied as an own client expense rather than put at the door of the insurers. Now, what that then meant was that where hitherto solicitors had simply contented themselves with the costs recovered from the insurers, they now, of course, had to make deductions from damages. And instantly built into the system was the potential for a conflict, a real conflict of interest between the solicitor and the solicitor's client. And in a sense, that's what Belsner had its origins in. In relation to the facts of Belsner, it concerned what might be described as a bog standard low-value road traffic accident case, which started under the relevant low-value protocol, proceeded into the Ministry of Justice portal, and was settled with the insurance company paying damages of just under £2,000, plus the fixed costs of £500, plus disbursements. The solicitors, acting for the client, retained the fixed costs and paid the client the damages less a success fee of £321.25. And then what happened was that the client instructed fresh representatives who brought a solicitor-owned client assessment on the client's behalf. And in front of the district judge, he found that the solicitors could reasonably have charged the client £1,392 for their work, plus a success fee of £208.80, rather than the £500 plus fixed costs of rather than £500 of fixed costs plus the success fee, amounting to £821. Now, the client, having been faced with those findings, then appealed to the High Court judge, Mr. Justice Lavender, who approached it on a fairly fundamentally different base. What he found was that the solicitors owed the client fiduciary duties when their retainer was being negotiated. He found that in relation to their written retainer, that had to be put forward on the basis of informed consent, with reference to Rule 46.92, which is a rule made under Section 74.3 of the Solicitors Act, and therefore found that the only viable charges that the solicitor could levy was in effect the £500 fixed cost plus a success fee of 15%, 75 quid, in circumstances. Now, underlining this, you need to understand what was really at work here. Section 74 of the Solicitors Act provides that, as far as contentious business is concerned, a solicitor can only make a charge in excess of the cost they get back from the other side if they have complied with rules of court. The relevant rule is 46.92, which provides that the solicitor must have made with the client a written agreement which expressly permits payment to the solicitor of an amount of cost greater than recovered from the other side. So when the matter went to the Court of Appeal, it dealt with some fairly fundamental points, namely whether Section 74 and Rule 46.92 apply to cases within the RTA portal, which settle without county court proceedings being issued, whether there was a fiduciary duty upon the solicitors when negotiating their own fees, and indeed, therefore, whether informed consent was required and whether that had been given, and whether the solicitors had to comply further with provisions of the Consumer Rights Act 2015, which went to the fairness of the relationship. Now, to cut a long story short, all of those points were resolved essentially in favour of the solicitors and against the client, with devastating consequences for the client, because the Court of Appeal took the position that if you settle a case through the MOJ portal, that is not contentious business. Therefore, the whole raft of considerations under Section 74 and Rule 46.92 simply don't apply. Also, they found that because the solicitors have an opposed interest to their client when they're negotiating their own fees, that's just inconsistent with any wider or deeper fiduciary duties. And they found, of course, that against that backdrop, the whole premise of Mr. Justice Lavender's decision effectively fell away. And then, of course, the Court of Appeal went on to deal with some of the other matters which were of significance, perhaps more generally, but not directly to the result of the case. One of the issues that the Court of Appeal dealt with was the practice that the solicitors had in that case of charging fees, but without the contractual cap upon those fees, which the Law Society model puts forward as an example of what can be done. The consequence of not having a cap, of course, was that although the solicitors had charged a perfectly fair and reasonable fee, they could have charged a lot more, in effect consuming the client's damages through unrecovered basic charges. And the Court of Appeal expressed some criticism of that approach, making it clear that there are obligations on solicitors under the Code of Conduct to consider their charging arrangements and to consider the information that they gave to clients as to what their own charges could be and how this would marry up with the deductions that might ultimately be made. It's also right to note that the Court of Appeal expressed extreme scepticism of the practice of bringing small claims effectively in the High Court against deductions of damages which were very modest, a few £100 in this case, and indicated that even if such a challenge succeeded under the Solicitors Act and the Special Circumstances Rule, a client might not be awarded the costs of the assessment, even if they managed to get some sort of refund. And indeed, the court pointed towards the legal ombudsman as being the remedy of first resort rather than the High Court for these purposes. In the related case of Karatysz, the Court of Appeal reiterated that point about how even successful clients could be deprived of their costs of the assessment if the proceedings were disproportionate as brought. And Karatysz dealt with two pretty fundamental points. Karatysz was concerned with what was the amount of the solicitor's bill. And the Court of Appeal decided, after a lot of forensic analysis and argument, that it's the amount demanded from the client rather than any other figures which may be floating around in the bill. And secondly, the Court of Appeal decided that when putting forward a bill, there were certain irredeemable or certain essential requirements that must be put into that bill to provide clarity for the client. And they explain what those were in the judgment. So When we look at these cases, they're important for a number of ways. The first is they're very important for solicitors who work in the bulk personal injury market because they're of direct application. Secondly, they're important for anyone who's going to be dealing now or in the future with online portals and protocols because of the distinction between contentious and non-contentious business. And thirdly, when we look forward to, say, October of 2023, and we have a much expanded system of fixed costs, where there will be even deeper deductions made from clients' damages, we can see that the sort of arguments which are made in the Belsner case and the considerations which are pertinent to how you draw your retainer, how good your estimates are to your client, and how you bill your client and what you include on that bill are going to bite with great force on those expanded categories of fixed costs going forward. Now, I'm going to pass the baton over to Craig to provide his take on this overall. What we're going to do as we go through is invite you to send in questions through the Q&A or through the chat box, and we'll pick those up and deal with them as best we can as we start to pull apart certain aspects of the decisions. But over to Craig for his take on this.
Thank you, Andrew. Well, dear listener, that was a fair, accurate, but somewhat speedy exposition through this, and I rather suspect our dear listeners will fall into two categories. There will be those that broadly understand what was determined by the Court of Appeal in those two cases, and there will be those who have joined into this simply because it probably counts as a tick in the box for their CPD points. But there is a wider and more fundamental message from all of this, and it's a sort of top and tail message from Belsner and Karatysz. Belsner's the sort of top of it all, in the sense that it's clearly there are going to be changes down the line to potentially the Solicitors Act and also to the rules of court, but they of themselves, when they come in, will simply muddy the water some more. What is clear even at this stage is that there is a criticism of retainers that do not make clear what it is that the client is going to be exposed to, but at the end of the case by way of costs. So that's the top. That's what you need to do at the outset. And what the tail is that when you then get to the end of the case, there is a requirement for you to bill with equal clarity. And it strikes me that the two are inevitably linked, because it's probably going to be difficult to send out a Gazette compliant bill in circumstances where you haven't got the retainer right at the beginning, because you won't have the basis upon which to do it. And so you're going to invite challenges along the line. And that taps into a point that I think needs to be understood, which is that although we are probably at this stage talking about firms that undertake, for want of a better way of putting it, bulk litigation, PI litigation, as Andrew quite rightly points out, as the fixed cost matrices are rolled out across different value cases, we're also going to see a rise in interest in this sort of argument. And it seems to me that after a while, it's also going to bleed out into other areas of law, such as commercial law and family law. And so it has a much wider application of getting the top and the tail in a correct format. One of the issues that's going to arise, though, if you don't get that, is that there's a general sort of business model across the industry where your initial retainer, whether it's a client care-based private retainer, or whether it's a CFA, or whether it's a insurance funded litigation, or via a union or some sort of BTE, invariably you're going to enter into an agreement that allows you to have checks paid over to you, which you'll then retain in your client account. And of course, all solicitors are fully aware that before they can move money from client account to their office accounts just to pay themselves, they're required to let the client know what it is that's being called upon. But at the end, when you get to the tail of this, and you then try to ensure that your client has a Kazakh compliant Section 69 Kazakh compliant bill, if you're going to pay yourself the shortfall and move the money from client account to office account so that you're being paid in the sense of Section 70, subsection 4 of the Solicitors Act, then the question is going to be begged, well, what constitutes payment? When is it going to be accepted? When you've got the top right and you've got the tail right, you've got the retainer right and you've got the bill right. What do you then have to do when you pay yourself by deduction so as to ensure that the time limit starts to run on all of this? So if you don't get that right, then the Solicitors Act sort of 12 months from payment long stop is never going to bite. And so you actually run the risk of having to have these arguments at 2, 3, 4, 5 years down the line, even though you think you've been paid. Now that's quite a lot of hurdles. And I hope, dear listener, those of you that perhaps have not taken as much interest in your retainers in the past, or have, shall we say, constructed your retainers, as Dr. Mark Friston calls them, by committee. You need to be aware that really Belsner may have headed off a particular type of attack. But what it's done is scratched at the surface. Because if your CFA doesn't allow you to do all of this, and you haven't within that CFA explained to the client the different ramifications of deductions emanating from fixed costs, emanating from costs at large, as to whether or not it is contentious business or non-contentious business, whether you have a right to payment by deduction, and if so, what inquiries you will make and what agreement you will have with them as to whether or not that deduction then constitutes payment for the purposes of Section 70, subsection 4 of the Solicitors Act, then this nightmare, this sword of Damocles that hangs over solicitors from firms who may seek to represent clients who are disgruntled about the deduction, it seems to me that it's cyclic. It never goes away. You can have a tax coming at you 3, 4, 5, 10 years down the line. And so I think it's important that the takeaway from all of this is not, oh, well, the Court of Appeal didn't like the arguments in Belsner, therefore the heat in the fire is going to go down. I don't think it is. I think what Belsner decided was a very narrow context, really. It was that, well, these aren't contentious. They're not within the auspices of the argument because portal cases are non-contentious business. I rather suspect that going forward, those sorts of arguments will not be capable of being maintained, because I rather suspect that the dividing line between what used to be contentious and non-contentious business, which we all used to believe was, well, it's non-contentious until you issue proceedings. The reality is that is likely, I think, to be changed, and we're going to see a requirement to give this sort of billing advice, this sort of costs advice, and have these sorts of arrangements as to how you will settle your account with your client front and center. And it won't matter a jot whether they are non-contentious or contentious. If you don't get it right, then you're likely to be in conflict with your client in the future, at least potentially. So for all those reasons, my takeaway from Belsner and Kazakh is not, oh, well, somebody got a bit of a bloody nose out of all of that, and it wasn't solicitors. I rather think that it's a little like the case of Myatt and Garrett back in the day, when we were all arguing about material breaches of the conditional fee agreements regulations. You may or may not, dear interested reader, remember and recall that Myatt and Garrett, when it had the argument as to whether or not it was a material departure or otherwise, was actually a case that was argued after the conditional fee agreement regulations of 2000 had been abolished. So in fact, it was never going to be a best practice guide to the industry at all. What it became was a checkers charter. And I rather wonder whether or not Belsner is the first salvo, as is Kazakh, of another round of a checkers charter. So, in fact, rather than it being the demise of these sorts of arguments, when the dust settles, it may actually be a rather fruitful landscape for others to move into. And therefore, look at your retainers, look at your billing practices, so as you ensure that what you are not are the next that are likely to be slaughtered on the fields of the next person who decides to take these cases. That's my take on it. I've realized already, as I'm hearing this all in my head, that you've all joined in thinking this might be fun and light-hearted. And in fact, both Andrew and I are just spreading doom and gloom, and it all sounds terribly technical. I hope that isn't the takeaway thought process that you have. I hope, in fact, that the takeaway thought process, dear listener, is one of, okay, yeah, we really do need to go back and look at our practices on a granular level, and we need to improve. And what we're not going to do is to do that by committee, because that is likely to lead, if it isn't well informed, to problems further down the line. So, Andrew, that's my very long-winded take on all of this. So I'm going to hand back to you to see what you say about that. I do hope you rather agree with me. I'll be embarrassed if you don't.
Well, I do, Craig, in essence. And I think, we can sort of build on that going forward, because when we think about matters going forward, let's deal with it in two ways. First, what the immediate effect of Belsner will be, and then let's just unpick some of the consequences in terms of, for example, the retainers. In terms of the immediate consequences, many firms still have a lot of cases. Solicitor-owned client challenges stayed in the Senior Courts Costs Office and in district registries around the country. And the question is then posed, what is going to happen to those cases, particularly because some of them are quite high profile. The Edwards case, for example, featured in parallel almost to Belsner. And the short answer is, of course, we don't know at the moment. Undoubtedly, the stay will be lifted, and then those cases will move to some sort of resolution. And that raises the very interesting question as to whether those cases are going to immediately explode because the substance of them went with Belsner, or whether there's other points to those raised in Belsner which will remain live, or whether indeed fresh and further points will go forward. And I agree with you that Belsner isn't the start or the end. It's a mere way station along the way. You can look at the origins back to 2012, 2013. You could look at the Herbert case in 2018. You can look at the points which are going to come through, I think, with added force, as we've already discussed on the fixed cost cases. But what does that practically mean for solicitors looking at their retainers? Well, many people listening will remember that the Law Society used to put out a model CFA. Indeed, you could helpfully download it from their website. At some point that I can't quite identify in the last few years, that model CFA quietly disappeared, and it's not been available, or indeed a replacement available, certainly in the run-up to Belsner. And reading between the lines, it may have been thought that there were certain potential issues with it, or just indeed a lot of uncertainty, so that the Law Society didn't feel able to give solicitors guidance. The fundamental problem, I think, is that because of the way the law is structured, it differs from what solicitors actually want to do in their retainers. I would suggest that in this sort of personal injury litigation, 99% of solicitors want to be able to charge the client the costs they get back from the other side, and 25% of damages. That may have increased if they're dipping their spoon into the very low value whiplash portal, but that's what they'd like to do. But that's the one sort of retainer, the hybrid CFA, which involves a charge by way of costs and then a percentage award of the damages, that the law forbids them from doing. And so part of the problem, part of the weaknesses in the retainer regime which were exploited in this litigation, was the fact that there was an artificiality to the retainer structure. We're going to charge you so much by per hour. We're going to charge you a success fee on the per hour. But at the same time, we don't really mean what's in the retainer. And when it comes to the bill at the end of the case, we're going to sort it out so that what we're charging you is fair and reasonable. But the Court of Appeal has expressly disapproved that sort of structure in the Belsner case. And it also has echoes in some of the other cases which have featured in the Solicitors Disciplinary Tribunal in recent years, where for low value litigation, solicitors were charging what at that time were extremely high hourly rates, topping £400 per hour, and found to have infringed various regulatory requirements as by the Solicitors Disciplinary Tribunal. And indeed, I'm thinking of a couple of instances where the solicitors who adopted those charging practices were, I think, struck off in the end. So these points matter. And I think the point that I would make is that if you've got historical retainers or charging on a historical model, Belsner, in effect, is inviting people to look at the retainer structure again and start to iron out some of the kinks, both in regulatory terms and also the fair and reasonable fee that solicitors want to charge the client at the end of the day. So, Craig, what do you think about the use of the Law Society model CFA going forward?
Well, of course, the Law Society model sits there in the history of CFA construction as being a sort of a boilerplate precedent from which all CFAs then grow organically. And of course, it always had significant problems, not least of which that it effectively declares itself as being not a contentious business agreement. Every model and that seems to be sort of carried over. And so it almost, so well, if it isn't that, then is it the other thing? So it immediately throws up its own problems. And whilst it might have, I hadn't realized it had mysteriously disappeared from the LawSocs website, it's still there in volume 2 of the White Book. It's still writ large in every volume that comes out every year. So it's still there, but it's fundamentally not fit for purpose going forward, is it? Because what it doesn't do, and what it's never really done, is address the kind of information as to costs that the client is likely to pay. And the reason that it hasn't done that is that it grew out of a period of time when this notion of charging a client a shortfall, which would be deducted from their damages, simply wasn't a model that was being embraced. This is there's always going to be exceptions to this. But I seem to recall there's a recent judgment that came out of the Senior Court Costs Office from the Chief Cost Judge Andrew Gordon-Saker, where he made an observation therein as to these deductions and said to his knowledge there's only really 2 firms that were doing it and that nobody seemed to do it before the 60th Amendment to the coming to the CPR and the coming into being of LASPO. So it's the irrecoverability in personal injury work party that seems to have fostered this idea of taking cost shortfall from the lay client. And of course, the Law Society model grew out of a world where that wasn't the norm. And so it's not a shortfall because it wasn't expected to ever have to address it. But the fundamental point is it says nothing about the costs that you're going to deduct from your client. And in fact, and Andrew, correct me if I'm wrong, because I'm just drawing from my own recollection of the LawSoc model. I don't think it ever had the Section 74 sub 3 Solicitors Act or CPR 46.9 sub 2 warning that we are entitled to deduct from you more than that which we recover by costs from the other side. So I don't think it was even, it wouldn't even get over first base. So if you have a standard Law Society model CFA and the business you are doing is outside the portal, it strikes me that you're in the crosshairs of a claim because you never had a right to make any deduction from the client out of their damages. And insofar as you have done, then that seems to me to be a breach of your contractual right with your client and a breach of the statute and a breach of the CPR, and therefore seems to offend as against the SRA Code of Conduct prima facie, in which case not only could those clients come over the hedgerow and say, give me my money back, but it strikes me that if you've got the Law Society model, the SRA might have something to say about you deducting monies from clients' damages when you had no right to do so.
That's a really interesting point, Craig.
That's the bit with the LawSoc thing, and I think is the difficulty.
Yeah, and I've seen the point argued both ways, because you're quite right. The Law Society model doesn't refer expressly to Section 74, doesn't refer to 4692, doesn't, for example, if you're claiming hourly rates which are higher than the guideline hourly rates, contain a warning about unusual costs. And you could say, well, if you're going to tighten the drafting, then it should contain these things. The counter argument would be to say, well, what Section 74 and 46.92 are getting at is that there should be an agreement in writing. And if the effect of that agreement is you can charge more than the fixed cost, then that will reach the statutory threshold. But that just illustrates the point that when Section 74 was enacted 40 years ago nearly, you were living in a different world where solicitors may or may not have had a written retainer at all. Inconceivable these days, but that's the origins of the safeguard. I'm conscious we're eating away at time, Craig. So shall we have a chat about this contentious, non-contentious point and where that might take matters?
Well, it seems to me that the it's tied up really with the Court of Appeal's observation, which was supported by both sides' advocates, that the Solicitors Act is in dire need of update. But insofar as it remains in its current guise, then there is a distinction to be drawn between the two, because the Solicitors Act makes a distinction. And so you're going to have to recognise that it's there. And until there's a change to the Solicitors Act, then the statutory basis for arguments about whether it's contentious or non-contentious is going to be addressed through that act. And as long as that is there, then it has ramifications, it seems, after Belsner, as to what you potentially at least need to tell your client in your retainer.
I think that's right, because, again, the Solicitors Act is predicated on the basis there's a hard division between the work you do before you issue proceedings and the work you do afterwards. And the significance of that for listeners who haven't dug too deeply in this is, of course, that there are different principles that apply to assessment of costs for non-contentious as opposed to contentious business. At least theoretically there are. At the end of the day, most judges will simply ask themselves, does this look like a reasonable bill to me? But I think the point that the Court of Appeal was particularly concerned with, and particularly what the Master of the Rolls was concerned with, because as we all know, he is a huge fan of technology and online matters, the blockchain and so on. Every speech he gives seems to be dripping with reference to the brave new world, is that when you're litigating in an online space, or even not litigating as we would regard it, but submitting claims via portals, the distinction between contentious and non-contentious may come to be a distinction without a difference. You send your claims notification form over the internet. Ultimately, you might send a Part 8 claim form over the internet. Ultimately, you might have a remote hearing before a district judge at stage 3 of any relevant protocol. But at what point does it become a meaningful distinction to say this is contentious and this is non-contentious? And so there's some force, I think, in the Court of Appeal saying, well, actually, this is a bit bonkers, and the Solicitors Act 1974 needs to be updated for the digital age.
I think that's right. I think it has its genesis in a different place. Plevin was the case that descended into the arena of a definition of proceedings. Really, prior to that contextual analysis of what was meant by proceedings, there was a more accepted hard line. It was why there was no difficulty in employment tribunals and matters of that nature. There was always seen as a bright line. That bright line, of course, has gone in practical terms. But it's still there, and it's there because it's an artifice of the Solicitors Act. The two are inevitably intertwined. So whilst for a sense of consistency and almost expedience, you could look to amend the Solicitors Act so as to remove that that dividing line. I think to do so throws up its own problems again. You can't just deal with one aspect of it, not deal with the other aspects of it, which is, by way of example, is that there's still a bright determining line in this country about where you can commence cases of this nature under the Solicitors Act. If your claim is over £5,000, then you can't commence it in the county court. You have to issue Solicitors Act cases in the High Court. But you also under Section 69, you can't issue assessments for non-contentious work in the county court, even if it's for less than 5,000. And so you if you're going to rework the Act, you need to rework the Act from the ground up. You don't start from saying, oh, well, it's an illogical distinction between contentious and non-contentious business, and so what we need to do is to change that in the Solicitors Act. No, you would need a root and branch revisiting of the Solicitors Act. And as part and parcel of that process, it strikes me that you have to then grapple with why you had this distinction between contentious and non-contentious. And you have to grapple with the movement of the understanding of what the word proceedings meant and whether or not that's going to remain pivotal to all of this. I mean, ultimately, you could say, well, it doesn't matter. But for reasons that I don't want to delve into, because we'll descend into an archaic 19th century analysis. There is a reason you have two different regimes. And there's a reason why you have these distinctions, and they don't just stay within a narrow confine. I mean, most solicitors who are having a deduction, let's just say they get it right. They've got a right to deduct from damages contractually. They get to the end of the case, the money's paid into their account. They decide that they're going to deduct. And let's just say that those solicitors firms that actually send a bill and don't just take it and don't just notify the client. They actually send a Section 69 Solicitors Act statutorily compliant bill. We have a delivered bill. Well, what's the form of that bill? Because there's, as I've always understood it, you can't send a gross sum bill in non-contentious work. So wouldn't you have a rather strange scenario where you've recovered fixed costs because it's settled at, say, stage 2 of the portal system? So your bill is very modest, but you're going to take the success fee. But in fact, in order to comply with the statute, you wouldn't be able to send simply a gross sum bill. You not only have to deliver a Kazakh type detail bill, but it couldn't be in gross sum. You'd have to detail it.
Well,
so it's throwing up, the whole point throws up all these sort of satellite questions that then descend down.
Well,
so the simple point is that this is something I strongly believe that the Law Society needs to involve itself in. The Solicitors Regulatory Authority need to understand what it is that they're engaging with. And therefore, it isn't just a case, to my mind, of updating the Solicitors Act. It's also it's a root and branch understanding of what it is you're changing, for what purpose, and how that is then going to be delivered compliantly in a digital age, ensuring while you do so that what you don't do is you don't either undermine the capable profitability of solicitors, or you drive a coach and horses through the consumer protections of clients. I always like it when we reach a pivotal point in development where we decide that the new generation knows better than the last generation, and therefore it's going to change the rules. And often when they do so, it's because they have no understanding of why the original rules were put in place in the first place. And I do wonder whether we're at a watershed moment in that evolution again.
Well, now, but let's move on in a moment to estimates and how those work. But I think you put your finger on some of the absurdities in the current regime, because you set out how you may not be able to have a gross sum bill in non-contentious work. There's an alternative construction to that section in the Solicitors Act, which indicates that, in fact, perhaps your true comparator is with the detailed bill, which can be requested by a client in place of a gross sum bill. And in effect, that's an additional right rather than a restriction upon what the solicitor is able to send to a client. Again, I've heard it argued both ways. And you also have, again, coming to another point you made, this absurd situation that if a client doesn't pay a bill of up to 10 grand and the solicitor has to take debt recovery actions, that's probably going to be a small claim in the county court, and you're going to have no cost recovery, though potentially there may be things to be done about that. But if the client challenges the 250 quid deduction, straight away you've got a high court case. Straight away you've got a deemed allocation to multi-track because it's a Part 8 claim, and the client gets full fat costs if they make out their case that the deduction was excessive. So you've got this huge dichotomy between the solicitor's remedies and the client's remedies, which doesn't really strike one as being very fair or indeed very logical as we go forward. We're now past the 22 points. So if we move on, Craig, to the cost estimate point, I think, again, one of the interesting points about Belsner was it highlighted the problems with solicitors not giving adequate estimates for cost going forward. And the fact that this meant it was difficult to calculate what any shortfall in charges would be. But it seemed to me, Craig, that wasn't just a problem at the start of the case. If you've got a case which does go forward, then the estimates going forward must necessarily be robust. But we come back to this point about how this marries in with cost budgeting. I mean, what do you think about a client's involvement with cost budgeting? Do you think that they should be sent the budgets for approval before and after the CCMC, or is it something the solicitor can leave effectively as a technical matter for themselves to deal with?
Well, I think, again, correct me if I'm wrong, but the original incarnation of the draft rules and the expectation was that the budget would be signed by the client. I think the original certification envisaged that it was the client that was going to sign it, not the.
I think that was the pilot. That was the pilot.
Yeah, it was in the pilot. Now, given the fact that that one of my sort of pet amusements is that whenever you speak to a solicitor, it's never the client's costs; it's their costs. Clients don't have costs; solicitors have costs. That's what solicitors will invariably tell you. But of course, the reality is they're not the solicitor's costs, they are the client's costs. And so the notion that you can leave it to the solicitor to draw the budget seems to me to be inevitably a disjoin from the reality. These are the client's costs. And I appreciate that that people will be shouting at their screen now, going, well, they don't care, they don't want to know, they don't want to involve themselves, we're running a business, etc., etc. I accept all of those factors. But the reality is that budgeting is about the costs that the client is going to be reasonably entitled and proportionately entitled to expend in getting to the end result. And that, of course, if you don't involve the client, not only does it seem to me that you've made the fundamental mistake of thinking these are the solicitor's costs, not the client's costs, but you are rubbing up against a real problem at the end if what you then try to do is take a shortfall of recovered costs from your client when they didn't know what the budget was in the first place. I think you're in a far more structured position if you've run that budget by the client, not only when it was constructed, but also then you have reported back to the client when the cost and case management has approved a budget as to what the state of play is. And you have given your client a breakdown of where you say there may be difficulties going forward. Because it seems to me that if there's a particularly stringent budget, you have a client who expects their case to be run in a particular way. And the reality is, therefore, there is a disjoint between the money that you've been allowed to expend going forward and the realities of what the client expects. Then you need to have on your file for future reference that you've had a robust conversation with your client, you've laid out to them the reality that then they are going to have to accept that that's going to come out of their damages, or they're going to have to also accept that there's going to have to be, at the correct point, if matters develop, applications to vary the budget and the compilation of a precedent T. There will be at different stages and for different reasons. You can't use a precedent T simply to try to put right what you considered was a too low approval of your future costs. But it seems to me they're joined up. So as we move into bigger litigation, the initial explanation to the client of costs and the estimates given need to bear some relevance to a reality. If you then go into budgeting, then it increases, in my mind, its importance and the involvement of the client, not only in constructing the budget, but the reporting back as to what the cost and case management has approved in each of the phases and what that means in reality for the client. So that when you get to the end and you inevitably now in modern litigation seem to be making a deduction, that the client has given some form of consent to that end result. And on that point, just to sort of final on it, I've recently had a case in the High Court. We're waiting for judgment on it as to what payment means for the purposes of Section 70, subsection 4 of the Solicitors Act. Most of the cases that have been argued on this are 19th century cases. And they talk about an account being taken. There seems to be a significant amount of import being placed upon this idea that before deductions were made, there was some form of interaction between the solicitor and the client, so as to give some form of outcome that the client understood. It seems to me that if you've got a budgeted case and the client isn't involved in the budgeting, then you've got a massive lacuna in that whole process. So that when you come to the end, it strikes me that any account you might be seeking to agree with your client is going to be problematic if it includes a shortfall in costs arising from the fact that what you've got in your cost and case management approved budget was less than what you've spent.
I think that must be right, because even if you look at it from a purely tactical position, if you've got client involvement and buy-in to the budget so that they're approving you spending the money that was disallowed effectively by the judge at the CCMC, then you're going to be in good fettle when it comes to a solicitor-owned client assessment to point to the presumptions in Part 46 to say, well, actually, you approved these items, you approved these amounts, and we incurred them, notwithstanding that we told you that we're not going to get them back from the other side. And so to that extent, you might take out a chunk of the controversy on a solicitor-owned client assessment. We're coming up to our last 10 minutes. I think we should have a chat about billing, but there's just a couple of questions I've seen in the chat and the Q&A, which are about this matter of contentious business and non-contentious. If you look in the Solicitors Act, I think the point that you'll note is that there's a definition of contentious business, which is the work done for and in the purposes of litigation or arbitration. And then the definition of non-contentious is, well, it's everything other than contentious business. And that, in a sense, can be a circular definition. But the key point is always to remember that if you have to issue the proceedings in the case, straight away, whatever you've been doing to date, relating back is going to be contentious business. The other point that's been raised, I think, in the chat is that what is the significance of this Delphic comment? The parties acknowledge and agree that this agreement is not a contentious business agreement within the terms of the Solicitors Act 1974. Well, it goes to this point. If it is a contentious business agreement, it restricts the scope of any assessment of costs that might take place. But it introduces, on the other hand, the court's ability to set aside the entire arrangement if it's judged to be unfair or inequitable. So you sort of pays your money and takes your chances, depending upon whether you want to put in place a contentious business agreement or not, and thinking about whether that's suited to the case and really what you think the scope of any potential dispute might be, depending upon what the client and the solicitor agree. So we've looked at estimates then and budgets and how they net into this. And what I thought we might do, Craig, is have a chat about billing in the last 10 minutes or so. First of all, can I throw this out to you? Do you think it's a good idea for solicitors to send their clients bills in cases?
You mean at the culmination?
At the culmination of the case?
Well, yes. Well, I think that they're required to. I mean, ultimately, any business that would want to draw a line under its income and expenditure and move on to the next financial year, and move on to the next quarter, move on to the and insofar as solicitors conduct business, then they have to have finality, and the finality is a statute bill. I mean, often these things are. I think sometimes because we do costs at the bar, we're a bit like policemen. You end up as a policeman believing that everybody might be a criminal.
Okay.
And there is an element, we see the worst of the drafting and the worst of the conduct, and because it crosses our desk. But I have to say that there are a couple of sort of urban myths that just keep being repeated too often to be just one-offs. The first is this sort of common belief amongst PI firms that seem to fall in, it rises regularly. I'm not saying it's all, but it just rises too often to be just coincidence, that they are entitled to take 25% of the damages. That's not what you're entitled to do. And anyway, if you were doing that, you've probably entered into a damages-based agreement, and in which case you might find that your whole setup is unenforceable. So that's the first myth. The second myth is that that you don't send a bill at the end of a case. What you do is you send a letter to the client, which isn't a bill at all, because it doesn't really comply with Section 69 of the Solicitors Act. It isn't a final statute bill. What it is a dear Julie, as per our CFA, we were entitled to do this. We've got this back from the other side. We've taken this out of your damages. Here's your balances check. No, you need to deliver a Section 69 statute bill if you want to start the process for which you can draw a line under your business like any other entity would do. And you need to be aware that there are 6 stages under Section 70, 6 time frames under Section 70 of the Solicitors Act, but they are all predicated on you having delivered a statute bill. And those timeframes then are linked to what the client can do to challenge your bill, at least for the purposes of a statutory assessment. They're always at liberty to have a general sort of complaint about you. But if they want to have an assessment of the bill, there needs to be 1, a bill, and 2, time starts to reflux. And if you don't do that bill, then none of that accrues. So it seems to me if you don't take that general principle step, then you run the risk of never being able to draw a line under that particular piece of commerce. You've paid yourself, you think, but in fact what you might be doing is simply borrowing some money from the client that you're eventually going to have to refund to them, and you may not realize that until a number of years down the line.
And I think in PI it's been a cultural thing, hasn't it? Because solicitors have never historically made charges to the client or levied charges on the client. They've never bothered to send them bills. They've taken the costs they get back from the insurers or whatever the compensating party is. But of course, the bill is fundamental. And if a client doesn't get a bill, one of the remedies they have under the Solicitors Act is to ask for an order of the court that they be delivered with a bill. And one of the nasty little traps, I think, that's lurking in the Solicitors Act is, although we often do everything these days, it seems, by email, the client's got to specifically agree to delivery of the bill by electronic means. And if you can't point to a clause in your retainer permitting that, well, then you have to start scrabbling about, don't you, for some sort of agreement by conduct or whatever it is, that everything would be done by email, and that can be difficult. There's some pushback, I think, Craig, in the chat which is saying, oh, do we need to do a statutory bill? And isn't this disproportionate?
Well,
would it
can I be clear? You don't need to do a statute bill to move money from client account to office account.
Yeah.
It's not what the solicitor's accounts rules require you to do. All you need to do is to tell the client you're going to do it. Yeah. But that's to conflate the problem with compliance with the solicitor's accounts rule. Yes, you can pay yourself, but my point is, if you don't issue a statute bill, if you don't deliver a statute bill and draw a line under payment so as to trigger the time processes within Section 70 by which the client can have a statutory assessment, then you might be under the illusion you've paid yourself, but you haven't. Potentially, at least, all you've done is borrowed money from the client that you're going to have to, in whole or in part, pay back, because they will have an enduring, it seems to me, in perpetuity right to seek a Solicitors Act assessment, because the window of opportunity, the 6 stages of Section 70, the trigger is you deliver a bill. So, and I look I appreciate all of this is systemized, but if ultimately you can you want to stay in an area of work and make it profitable, then it needs to be profitable. And there's no point in remaining in an area of work if the simple fact is it isn't going to be profitable, because further down the road you're going to have to fight off challenges from your clients who want an assessment at a period of time when you think this is long gone.
And if you looked at the worst case scenario, if a firm's practice is not to send out own client bills, deliver them, you could have stacking up in the basement hundreds, thousands of cases year on year, which, if somebody ever got hold of those clients, would lend themselves to mass challenge, which may be at a relatively low level, but cumulatively could be devastating. So it really is playing with fire if you haven't got your billing practices sorted out.
But it also does. There's that point as well, that it might be for modest sums. If you're doing bulk PI work, say, and you don't do a statute bill at the end of it, but what you deduct from the client, say, is modest, say it's a few £100s, and you might say, well, we're not really bothered, because if it all came on top, we'd take a view. Well, just pause for a minute. What is the aggregate of all those sort of few £100s? But also, what is the cost of the practice of dealing with an assault on the firm, with hundreds of those suddenly coming through? How are you going to respond to them within the times envisaged by the protocols? How are you going to deal with that? So the simple way is to top and tail it. Get it right in your retainer, get it right in the billing, put it in the basement, and the chances are it won't come back to haunt you, or if it does, you'll bat it off in fairly short order. But more importantly, whatever you've transferred from client account to office account can now be expended without it having the sword of Damocles of turning into a loan 4 years down the road.
I think that has to be right. When you're looking at tightening processes, as we've discussed, retainer, estimates, billing, these are the touch points going forward. We're now down to the last minute or so. Craig, what do you think about the Court of Appeal's preferred choice of the legal ombudsman for dealing with low value cost disputes? And Craig, can you keep it clean and printable as this is being recorded?
Yeah, well, isn't it? It's sort of dripping with irony. Let's just assume, for the purpose of this, that the legal ombudsman has got the people in place to deal with all of this in a reasonable period of time. But isn't the fact that really the threat was, if you keep issuing these in the High Court, then when we get to the end of the assessment, even if you beat the 1/5 rule, you probably still won't get your costs. Now, this is in a judgment. This is being said in a judgment where there's a criticism of solicitors for not telling the client what their exposure to costs is. Well, if you follow that logically through to the end, you've got a situation where client comes to you and says, I've had deductions from my damages, what should I do about it? The new solicitor has to say, well, hang on a minute. we're obliged under statute to issue in the High Court. The statute, the Solicitors Act says that if we get an assessment and we reduce it by the 1/5 rule, there's a presumption you'll get paid. But I have to tell you that you may not recover, but I can't tell you what the rules are because I don't know what the court will view about whether your case is trivial or otherwise. And so I can't tell you what the adverse costs are going to be. So you'd find yourself committing the very heresy that the Court of Appeal have criticised, despite the fact that you are mandated, you have to go down the High Court rule. So you have to issue it there. And you can't tell the client anything about costs other than, well, if the court subsequently thinks that your case was trivial, even though there's the presumption created by statute that you'll get your costs because you've triggered the 1/5 rule, you may not do. So I find the whole notion of going to the ombudsman interesting purely because it's really, well, I hope they're not too busy, but it's actually not the ombudsman part that I find engaging. It's the fact that you're being sent there because it's a criticism of wasting the senior court's time with this sort of issue, when in fact you're mandated by the rules to do that.
Well, we'll have to see whether there's a logjam in the ombudsman as a result of Belsner and its clear direction there too. But I think, Craig, we can wrap it up there. We've run slightly over, but it's time to get back to the football, and it's been a delight as always. So shall we leave it there?
Thank you. Take care, everyone.
Thanks for listening. Cheerio. Bye-bye.